A very good morning to one and all present here and going through a very important module talking about minority rights. What does come to one's mind when they hear this word minority, or when they see the Indian position relating to the minority, or when one thinks about the Indian Democratic Republic? Does it not ponders on your mind that majority rule and minority rights? This is what applies to the Indian Democratic Republic. With this, I start my module on minority rights and would like to first introduce the listeners to the learning outcomes that one will be able to understand and grasp after going through the particular module. The first learning outcome will be an in-depth understanding of the concept of minority rights. Here, when I say in-depth understanding of the concept of minority rights, it will basically make you understand what do you understand by minorities, and how does Indian Democratic Republic or the constitutional law, which is the sovereign law of the India, protects and safeguards the minority rights. Second, you will be in a position to understand the evolution, development and conceptualization of minority rights. You will be in position to bifurcate the conceptualization from the Vedic age to the Britishers and to the post-independence period. The third learning outcome of this module will be understanding of the constitutional provisions guaranteeing rights of scheduled caste and scheduled tribes. You will understand all and where the constitution talks about safeguarding and promoting the rights of the scheduled caste and scheduled tribes. And the fourth and the very important outcome will be the study of the judicial response towards minority rights. There have been a series of cases where judicial pronouncements have given new way, or we can say that they have molded minority rights, or they have safeguarded, promoted and made minority rights have a stronger position in the Indian polity. Starting with the introduction, which is very important for this particular module, I would like to say that minority rights have gained greater visibility and relevance all over the world, and India is no exception to it, being a multi-ethnic, multi-religious, multi-linguistic and multicultural society. I think you will all agree that India is a country which is mix of multi-ethnic, multi-religious, multi-linguistic and multicultural society, where language changes after every 3 miles, where people are secular in nature. The country does not promote or encourages any particular religion, and ethnicity and brotherhood are the essence of our soul. So, we can say that India, being a country of multi-ethnic, multi-religious, multi-linguistic and multicultural people, is no exception and cannot avoid not promoting and safeguarding minority rights. We can say that diversity of all types is the very soul of India. It is in this context that minority rights have assumed added significance in post-independence India, because after the making up of the constitution, it was on the shoulders of the constitution framers that whatever wrong has been done to the people in the past should be done right when the framing of the constitution was taking place, and the constitution should give special promotion and preservation of the rights of the minorities. The prevention of discrimination seeks to secure that everyone as individuals are treated on an equal basis, and this was what the constitution framers aimed at. To come in particular, the Constitution of India has given recognition to a number of languages in the 8th schedule. This was the start when multi-ethnic, multi-regional, multilinguistic society was woven into one thread. And there existed 5 religious groups which have been given the statutory status. You can just imagine that 5 religious groups which prevail in minority were given statutory status to national minorities, and these communities were namely Muslims, Sikhs, Buddhists, Parsis and Jains. Today, minority rights have introduced 2 new magnitudes into democracy. First, they made community a legitimate subject of political dialogue, and second, they placed the issue of intergroup equality on the agenda. When I say intergroup equality, it means that the Constitution has to provide and promote safeguards so that the intergroup equality in the multi-ethnic society of India should come to an equal footing. The framers of the Constitution bestowed considerable thought and attention upon the minority problems in all its facets and provided constitutional and statutory safeguards. Yet, the issue has evaded solution till today. All steps were taken by the Constitution framers and all provisions have been laid down in the Constitution of India. Still, there are certain questions about problems between the majority and minority which still exist and still need an answer. The first question which emerges because of the difference or the problems between the majority and minority is, what status has the polity granted to its minorities? What are the problems faced by the minorities, especially in the context of inclusion and exclusion in state building in post-colonial India? How are they able to assert themselves? Very, very important questions, that what are the provisions, and if provisions are there, are they being implemented properly? Next, what is the role and extent of their participation in politics and socio-economic development? And a very, very important questions which is there, which is unsolved and unanswered, is what is the extent of prejudice and discrimination faced by them still today? In order to answer and compensate the minorities for the wrong done to them in the past, compensate the members of the discriminated groups who were placed at a disadvantaged position, Article 15 subclause 1 of the Constitution of India specifically bars the state from discriminating against any citizen of India on grounds only of religion, race, caste, sex, place of birth, or any of them. Specifically, I quote Article 15. It talks about prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. I quote 15 subclause 1. It states, the state shall not discriminate any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. This means that a very strict and stringent provision has been laid down in the Constitution of India to safeguard and protect the minority rights. After understanding how the position of minority rights that have evolved post-Constitution period, now we should move on to first understand that what does minority mean. In general, the term minority, it means and shall include only those non-dominant group in a population which possesses and wish to preserve ethnic, religious, or linguistic traditions or characteristics markedly different from those of the rest of the population. If I come down to specific definitions which have been quoted by Louis Wirth, he defined a minority as a group of people who, because of their physical or cultural characteristics, are singled out from the others in the society in which they live for differential and unequal treatment, and who therefore regard themselves as object of collective discrimination. So, if we analyze Louis Wirth's definition, we see that minority is a group of people who do not find themselves to be part of the mainstream population and who consider themselves to be objects of collective discrimination. According to Francisco, UN Special Rapporteur, in his report, he has laid down what constitutes a minority. He says that a group numerically inferior to the rest of the population of a state in a non-dominant position, whose members being nationals of the state possesses ethnic, religious, or linguistic characteristics different from those of the rest of the population if only a sense of solidarity ponders in them, directed towards preserving their cultural traditions, religion or language. So it means that a group of people who want to preserve their culture, tradition, religion or language, they constitute a group which is not part of the mainstream and they are termed as minorities. After understanding what minority means, we move on to the conceptualization of scheduled caste and backward classes, that how did this concept emerge, what did it meant in the pre-Vedic period, and how did it gain momentum during the British period, and how it found a place in the Constitution of India. The earliest reference to the caste system is found in Rig Veda, in which it mentioned that there exist 4 castes which originated from Brahma, the supreme being. It was believed that the Brahmins came from the mouth, Kshatriyas from his arms, Vaishyas from the thighs of Brahma and Shudras from his feet. And since Shudras emerged from the feet of Brahma, this meant that Brahmins were the instructors of mankind, Kshatriyas were the warrior class, and Vaishyas and Shudras were agriculturists and servants respectively. This means that the Shudras, when they emerged from the feet, their work was only of that of the servants. There exists a great difference between the first 3 and the last one. The present day scheduled castes were included in the category of Shudras. Shudras were associated with unclean occupations like night soil and throwing of dead animals, etc. So from this we derive that from the time of the Rig Vedas or from the very early times, the class that is called the scheduled caste and the backward classes in the present circumstances and called the Shudras in the time of Rig Vedas were not treated equally or were treated like animals from the very time of the Rig Vedas. The term scheduled class was adopted for the first time in the year 1935. From Shudras, we moved on to scheduled class. When the lowest ranking Hindu caste was enlisted in schedule appended to the Government of India Act for the purpose of statutory safeguards and other benefits to them. So, for the very first time in the Government of India Act 1935, there was a list appended, or we can say a schedule appended, in which the lower caste Hindus were enlisted as scheduled caste. The Britishers played a dominant role in the awakening of India towards the plight of the scheduled caste. They ushered the principles of complete equality and justice irrespective of race, color, caste, creed, religion, etc., which the Constitution framers had incorporated in Article 15 subclause 1 of the Indian Constitution. Subsequently, after independence of India, with the coming of Constitution of India, efforts were made to uplift the social status of the minorities. The Constitutional Assembly was very much concerned about the issue of protection of minorities and other weaker sections of this country. The committee deliberated various matters in 2 subcommittees, various matters related to the protection and preservation and position of the minorities, the Fundamental Rights Subcommittee and the Minority Subcommittee. Here, it is noteworthy that the Minority Subcommittee was specially constituted to look into the matters of the protection and preservation of the rights of the minorities. The backward classes can be identified. Here, I am talking about scheduled caste and backward classes. So, it is very necessary to understand how do we categorize backward classes. The backward classes can be identified by the central and state governments on the basis of criteria recommended by commission or committee constituted under Article 340 of the Constitution of India 1950. Article 340 specifically says that appointment of a commission to investigate the conditions of backward classes. It says that the President may by order appoint a commission consisting of such persons as he thinks fit to investigate the conditions of socially and educationally backward classes within the territory of India and the difficulties under which they labor, and to make recommendations as to the steps that should be taken by the Union or any state to remove such difficulties and to improve their conditions, and as to the grants that should be made for the purpose by the Union or any state state and the conditions subject to which such grant should be made, and the order appointing such commission shall define the procedure to be followed by the commission. So, in 1950, in accordance with Article 340 of the Constitution of India, the Kelkar Commission was appointed in 1955 and the Mandal Commission in 1980 to look into the conditions of the working of the backward classes. No fixed criteria for identification of other backward classes has been provided by the Kelkar Commission, though these commissions were set up to identify and lay down the different criteria for identification of other backward classes, but no fixed criteria was laid down by the Kelkar Commission. The Mandal Commission held that socially and educationally backward need not necessarily be economically backward classes also. The Commission found that class backwardness was commerce and industry. So these were the criteria which were decided for declaring a class to be backward. Now moving on, after understanding what are scheduled castes, scheduled tribes and the backwards, we move on to the specific provisions which have been laid down in the Constitution, Indian Constitution, for protection of scheduled caste and backward classes and also for their promotion. Recognizing the special needs of scheduled caste and backward classes, the Constitution of India not only guarantees them equality before law under Article 14, but also enjoins the state to make special provisions in the favor of scheduled caste, scheduled tribes and backward classes for their upliftment in the society under Article 15 subclause 4. It also empowers the state to make provisions for reservation in appointments or post in the favor of any backward class citizen under Article 16 subclause 4. In Constitution, the provisions guaranteeing protection of scheduled caste and backward classes can be studied under three heads, that is protection of social interest of the minorities, protection of economic interest and protection of political interest. Moving on to the first classification, we will first see the protection of social interest. The protection of the social interest of the minorities have been laid down in Article 14, which talks about there should be equality before law. It means that no one should be discriminated on the basis of caste, color, sex, creed, etc., but everybody is equal before law. Secondly, Article 15 subclause 4 talks about protection of social interest by laying down that special provisions for the advancement of any socially and educationally backward classes, including SCs and STs, should be made, and this provision for making of such provisions for the advancement of any socially or educationally backward class have been specifically laid down in Article 15 subclause 4. The Constitution of India also provides for protection of the social interest by laying down abolition of untouchability, and its protection in any form is forbidden. It means, and it has been laid down in Article 17, that there can be no untouchables and untouchability cannot be practiced in India. Under Article 340, it has been said that there should be a commission appointed to investigate the conditions of socially and educationally backward classes. Under Article 30, it has been said that the right of all minorities to establish and administer educational institutions of their own choice should be made available to the minorities. Lastly, under Article 341 and 342, it is said to specify the caste and tribes community deemed to be SCs and STs, and their social and economic interests should be protected. Moving on to the economic interest, that has been laid down under Article 46, which says that to promote with special care the educational and economic interest of the weaker sections and in particular to the SCs and STs, and to protect them from any social injustice and all forms of exploitation. Secondly, under economic protection or the protection of the economic interest, we will move on to Article 275 subclause 1 of the Indian Constitution, which says that special financial assistance or funds is charged from the consolidated fund of the India each year as grant and aid for promoting the welfare of the STs and the development of scheduled areas. Also in Article 335, the claims of SCs and STs to appointment in services are safeguarded. Moving on to the last area of the protection of political interest, we will first see Article 224 and 339 of the Indian Constitution, which talks about administration and control of the schedule. This is a very important, these are very important articles, that by these articles, when we reserve the seats for SCs and STs, and in the present scenario after the 73rd and the 74th amendments, also in the municipalities and Panchayati Raj institutions, seats have been reserved for the SCs and STs so that the political interest can be safeguarded and promoted. Likewise, a number of constitutional provisions exist for protection and promotion of the interest of these socially disadvantaged groups. Moving on not only to the constitutional provisions, but moving on, we see that the Indian judiciary has also played a very vital and important role in laying down the various rights and promoting and safeguarding the minority rights by deciding a series of cases. The Indian judiciary has safeguarded the rights of the 49 who are in minority in India and have been on disadvantaged position. That means that Indian judiciary has played a very vital role for the disadvantaged 49% out of the 51% of, and the rest of the 51% of the Indian population, which already enjoys all the rights and privileges. When the Constitution of India under Article 15 subclause 1 and further under Article 29 subclause 2 gave protection to the minorities, challenges were made to governmental programmers aimed at making special provision for weaker sections of the society in the field of education and housing. Two judicial decisions, one of the Supreme Court and the other of the Bombay High Court, led to the first amendment of the Constitution in 1951. There are specific cases which I am going to further discuss, which led the judiciary in changing the direction of reservation in India. But first, we will discuss the case of State of Madras versus Champakan Doirajan, which is considered to be the milestone case in bringing protection and promotion of the rights of minorities. This case was with regard to the admission of students to the engineering and medical colleges of the state. The province of Madras had issued an order known as the communal GO that seats should be filled in the selection committee strictly on the following basis, that is, out of every 14 seats, 6 were to be allotted to non-Brahmins, that is Hindus, 2 to backward Hindus, 2 to Brahmins, 2 to Harijans, and 1 to Anglo-Indians and Indian Christians, and 1 to Muslims. In this case, the full bench, or we can say that the court held that the communal GO constituted a violation of the fundamental rights guaranteed to the citizens of India by Article 29 subclause 2 of the Constitution, namely that no citizen shall be denied admission to any educational institution maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste, language, or any of them, and was therefore void. Under Article 13, the directive principles of the state policy laid down in Part 4 of the Constitution cannot in any way override or abridge the fundamental rights guaranteed by Part 3. On the other hand, they have to conform to and run as subsidiary to the fundamental rights laid down in Part 3. In another very important case of Jagwant Kaur versus State of Bombay, the court held that Article 46 should not override a fundamental right, and consequently the orders which were laid down in the case of Jagwant Kaur were declared void. Coming down to what this case dealt with. In this case, an order of the Collector of Pune under Section 5 of the Bombay Land Requisition Act for requisitioning some land in Pune for establishment of a Harijan camp was challenged as violation of Article 15 subclause 1. The basis of challenge was that a colony intended for the benefit only of Harijans was discriminative under the above constitutional provisions, and as I have already said that it was held by the court that this order was void, and it was said that Article 46, which is a directive principle, cannot override a fundamental right. Coming down to how the first amendment in the Constitution took place in order to add the rights of the minorities. It was at the time of decision in the case, the first amendment had not come into effect. That is, in the case when Jagwant Kaur and Champak Doi Rajan were held, the decision to the first amendment had not come into effect, and Chief Justice Chagla observed that after the amendment it would be possible for the state to set up a Harijan colony in order to advance the interest of the backward class. But till the amendment was not enacted, as Article 15 stood, it was not competent for the state to discriminate in favor of any caste or community. Thus, it may be pointed out that it was these two decisions which led to the amendment of Article 15. The first amendment incorporated clause 4 to Article 15, empowering the state to make special provisions for the advancement of any socially, educationally backward class of citizens or for the scheduled caste and scheduled tribe, despite Article 15 subclause 1 or clause 2 of Article 29. The object of first constitutional amendment was to bring Article 15 and 29 in line with Article 16 subclause 4, which specifically empowers the state to make special provisions for the backward classes in matters of public employment. The addition of clause 4 to Article 15 opened doors for several petitions before the court, and the court have wavered on the interpretation of this clause in several cases. There has been a series of cases after the addition of clause 4 to Article 15, and these cases gave rise or directions to reservation system in India. Now, we are going to study a few of the leading cases which gave new lines and waves to the reservation policy which is prevailing in India. Coming down to the first and the foremost important case of Balaji versus State of Mysore, in which it was held that reservation cannot be more than 50%, the classification of backward and more backward is invalid, and caste cannot be the only criteria for reservation because Articles 15 subclause 4 talks about class, and class is not synonymous with caste. So, other factors such as poverty should also be considered. Moving further, in the case of Devadasan versus Union of India, the Supreme Court has held that the carry forward rule as unconstitutional. As per carry forward rule, posts that could not be filled due to lack of candidates in backward classes would be filled by regular candidates, but the same number of additional posts would be reserved in the next year. This caused the amount of reservation to go above 50%. Supreme Court held that power of Article 16 subclause 4 could not be used to deny equality of opportunity for non-backward people. Moving further, in the case of Indira Sahane versus Union of India, it was held or it was mandated that reservation ordinarily should not exceed 50%. This case was in continuation to the case of Devadasan, and it said that it submitted that this view is correct as reservation is an exception to the general principle of equality, and as such an exception cannot exceed the main principle. The Supreme Court, after considering the various aspects of reservation in series of cases, analyzed, examined, scrutinized and reviewed the constitutionality of the reservation system under Article 15 subclause 4, 16 subclause 4 and Article 340 of the Indian Constitution in modern perspective in well-reasoned and elaborate case of K.C. Vasant Kumar versus State of Karnataka, in which a bench of the Supreme Court consisting of Justice Chandrachud, Justice Desai, Justice Chinnappa Reddy and Justice Sen and other justices held that the reservations in favor of scheduled caste, scheduled tribes and backward classes must continue as it is in the present form and for a for the period not exceeding 15 years. But the policy of reservation in the employment, education and legislative institutions should be reviewed after 5 years or so. The criteria to judge the backwardness should be the economic backwardness, and reservation should not cross a reasonable limit of preference and discrimination. Recently, the Supreme Court in Dr. Faisal Gaffar's case held that there should not be any reservation in the field of specialities. If therefore preference has to be given, it should not exceed 35% of total quota. After an in-depth understanding of concept of minorities and safeguards provided to protect their interest in Constitution as well as by judiciary, we can conclude by saying that on an analysis of the series of cases, it can be said a comparison of socially and educationally backward classes with the scheduled caste and the scheduled tribes in Article 15 subclause 4 were to be construed as including such backward classes as the precedent may by order specify on receipt of the report of the commission appointed under Article 340 subclause 1. It shows that in the matter of backwardness, they are compared to scheduled caste and scheduled tribes. The concept of backward classes is not relative in the sense that any class which is backward in relation to the most advanced class in the community must be included in it. So, we can see by the series of cases and the constitution provisions, we can conclude that minority rights in India post-independence have been safeguarded, have been promoted and have been encouraged not only by the framers of the constitution but also by the present administrators and the legislators and judiciary. Thank you.